Welcome to another episode in the podcast called Labor Matters, where I address trending issues and queries in employment law, specifically within the Barbadian context. I'm Michelle Russell, attorney at law, and I have a passion for employment law and labor matters, and I'm also a self-described budding social activist. I am a columnist for the Nation newspaper, where I write a weekly column for the Sunday Sun that addresses employment law and labor matters, so that if you want to learn more about your labor rights, don't forget to get your copy of the Sunday Sun. Now for this week, we are going to be looking at a topic that I hear a lot and that people consult with me on a lot, and that is victimization in the workplace. So we're going to look at it from three different angles. We're going to look at what is victimization. We're going to answer the question whether there are legal protections in Barbados for victimization in the workplace, and we're going to address what you should do if you believe you are suffering victimization at work. So that's three things. We're going to look at what exactly is victimization, are there legal protections for victimization in the workplace, and what you should do if you believe that you've been subject to victimization at work. So let's just get straight into it and look at the definition, or at least a very simplified explanation of victimization. Now, in short, victimization occurs where an employee suffers some form of detriment in response to a complaint that the employee made, or in response to relational difficulties that the employee might be having with a superior or a direct report. So victimization occurs where the employee suffers some form of workplace detriment as a result of making a complaint, and the complaint could be about workplace practices, the complaint could be about the contract of employment, it could be anything relating to the workplace. So the employee made the complaint, and as a result he is subjected, or she is subjected, to workplace detriment or relational difficulties with a superior. That is the most simplified form of the definition for victimization I can give. But victimization can take several forms. It can be in the denial of workplace advantages or accommodations. So for instance, you might be put in the corner where the lighting isn't good and the AC blows straight on you. That's a denial. You could be requesting a change in your chair because it's uncomfortable and it's hurting your back, or your computer keeps crashing and you ask for a change in the computer. Everyone else gets one, but you don't. So that's a denial of workplace advantages or accommodations. And advantages include stuff like promotion. So you could be denied advantages. You could be denied training, the ability to go off-site to represent the company, all because you made a complaint in relation to your employment conditions or in relation to another superior or another co-worker. Now, victimization also includes unfavorable treatment of the employee, which stems from the complaint. Now, this is the one you see the most, where persons talk about the relational difficulties they're having with a superior. The superior is very critical. The superior issues warning letters sequentially for every possible thing that's done wrong. If they come to work 2 minutes late, the superior is down their back. They get a bad performance review, even though the work that the employee did does not support the bad performance review. At the very least, it supports a satisfactory one, but that all of the criticisms are essentially being done out of spite by the superior because of the complaint and or relational difficulties that exist between the employee and the superior. Another form of victimization is purposely giving unfavorable performance reviews, like I just mentioned, and giving the employee unfavorable terms and conditions of employment. And sometimes they do this to squeeze you out, you know. So they ask you to stay at work later. All of a sudden you have to come in on public holidays and you have to work on weekends. And I'm talking about industries where your contract of employment or the culture within your office is that you don't get paid for overtime. This tends to be more administrative roles where whatever salary you get is limited and you don't fall under the Shops Act, so that you're not entitled to payment. So you're given crazy deadlines to produce material, that the only way to meet the deadline is to be working on the weekends, working late at nights. And then when you finish one, they give you more, and you don't have assistance. So you need more people in your department because you're asked to fulfill way too many roles. And then when you're unable to fulfill all the roles because shortage of staff, you are still given a bad performance review because they try to squeeze you out. So they give you more than you could possibly handle. They give you deadlines you cannot handle. They don't care if you're sick. You don't get to take your vacation days. They don't care of the emotional distress the overworking is causing. If you try to bring your child to work, they complain about the child being there. If you try to leave to go pick up the child, they tell you must do it in your lunchtime. So it's all to give you unfavorable working conditions in the hope that you'll resign, or in the hope that they'll find some flaw in you that they can give you sequential warnings and then eventually try to dismiss you. Another kind of victimization is subjecting the employee to unfounded and unnecessary or spiteful disciplinary action. And I mentioned that when I said like sequential warnings. So that they say to you, today you were late 3 times this week. You need to do better. And that's the Friday you get the letter. And by Tuesday, they're giving you another letter saying this is a warning, you were late once this week. So it's like they don't give you a reasonable opportunity to improve before you get another warning letter. So that is subjecting you to unnecessary disciplinary action. You may also be invited to disciplinary proceedings on things that are unfounded, very sparse allegations of theft, and all that happened is that you were in the room where the thing was stolen, but the thing was stolen before the time you were in the room. But it's a superior who is doing this on purpose to essentially make your life miserable. So these are all examples of victimization, but it's not limited to these examples. But really the test is whether there's a workplace detriment that came as a result of relational difficulties with a superior, or as a result of a complaint you made about working conditions. And the complaint could be a complaint for the superior. The complaint could be a complaint about the workload. It could be anything. But the detriment and disadvantages must be directly or able to at least be indirectly attributed to the complaint. The only way to be able to prove victimization is you have to have evidence. So you're going to have to be very good in keeping records, dates, times, video or audio recordings of some of these meetings, etc. Or it will be difficult because in circumstances where the detriment can be explained away by something else, you are less likely to be able to succeed on a claim for victimization. So for instance, if you say, you know, I didn't get the promotion, even though I'm the most senior person here, I have the most experience and I've had very good performance reviews, so that the only reason I'm not getting it is because my boss doesn't like me because I complained for her. But if they can say, no, you didn't get the promotion because the post requires a master's degree, and though you're the most senior, you don't have a master's degree, it means they can explain it away. So you may have been right. It might be that the superior was fighting you in not giving you the promotion, but so long as it's difficult to prove a direct link between the complaint and the detriment, it'll be difficult to prove it, and that's why record keeping will be important. Now the second question is, since we know victimization exists and we see it in the private sector, we see it in the public sector, what if any protections are offered by the law? Now this is where it gets a little tricky, because unfortunately there is no general right of action for victimization. So it's not every victimization that is protected, you know, it's not every kind of complaint that is protected. Because remember, victimization is workplace detriment as a result of a complaint. But the law unfortunately only protects 3 types of complaints. Complaints in respect of sexual harassment, complaints in respect of discrimination in employment, and the last one being where you were fired as a result of complaining about a workplace practice, contract, etc. Outside of those 3 instances, there's really no legal protection against victimization. So we're going to look at those 3 instances right now. Now the first one is under the Employment Prevention of Sexual Harassment Act. Alright? This is an act that came in 2017, which essentially guarantees every employee the right to have a workplace free of sexual harassment. Now the legislation is quite detailed, and it sets out what is sexual harassment, which we'll find in section 3 of the act, and how an employee should go about making a complaint for sexual harassment. And in the first instance, the complaint should be made internally via the workplace processes, which is normally through HR or some senior management. But in certain instances, the complaint can be made directly to the labor office, like when the sexual harassment is directly from the CEO, or where it has to do with an unfair opportunity that's being provided to a co-worker who's given a superior sexual advances. All right. But in all other instances, you normally have to go through the workplace procedure first, and make the complaint, and if it's not properly resolved or if you're not comfortable with the resolution, then you go to the labor office. Now what can happen in instances where you make a complaint for sexual harassment, especially against a superior, a direct report, they might spite you. They might try to silence you from that complaint, and that is where victimization takes place. So they might make your working life miserable because you complained for them. They might deny you promotions, any number of things, because you made the complaint of sexual harassment. But what the Act did in Section 26 is that it prohibits an employer from victimizing an employee solely on the ground that they made a complaint for sexual harassment, or that they proposed to make a complaint for sexual harassment, or that they helped someone who made the complaint. And by helping, it could be you assisted in giving testimony on behalf of the victim, you participated in the investigation or the hearing or the proceedings, whether they were internal proceedings or at the labor office. So that Section 26 says an employer shall not carry out any action which adversely affects the opportunities and terms and conditions of service of an employee who rejected the employer's acts of sexual harassment, who lodged a complaint for sexual harassment, who gave testimony in any investigation conducted or hearing held under this act, or who participated in an investigation or proceedings under the act. It also says, and it goes a step further, no person shall subject or threaten to subject another person to any detriment on the ground that he made or proposes to make a complaint, that he furnished or proposed to furnish information or documents to assist in the complaint, or that they attended any inquiry to appear as a witness. So in other words, you can't victimize someone because they made the complaint or helped with the complaint or proposed to make the complaint, but you also can't threaten them. You can't say, well, if you complain for me, I'm going to make your life a living hell. That would breach the act. And what is good is the act doesn't just prohibit it, but it creates a penalty. It actually says in subsection 3 of section 26, a person who contravenes this section, in other words, if you victimize the employee in any of these instances, then you are guilty of an offense and liable to a fine of up to $10,000 or imprisonment for 2 years, or both. And that penalty is fairly high, and it would be in respect of each employee that was victimized in the sexual harassment proceedings. So that it's supposed to be a deterrent to keep the employer from victimizing the employee, and to make sure that the employer puts controls in place to make sure no other employee is victimizing that employee or victimizing the complainant, as we call them. So that the first instance in which the law protects an employee from victimization is where you made a complaint for sexual harassment. Now the next instance in which the law protects an employee from victimization is indiscrimination claims. Now under the Employment Prevention of Discrimination Act, which is a recent act that came out in 2020, the act itself prohibits an employer from victimizing an employee who makes a complaint for discrimination or who proposes to make a complaint for discrimination, and it prevents an employee from threatening to victimize an employee who proposes to make the complaint or who assists in the complaint. So it's very similar language to the protections offered under the Sexual Harassment Act, so that any employer who victimizes an employee simply because they made a complaint under the Discrimination Act, they made a complaint that they were being discriminated in employment, and they victimize the employee, the legislation says that the employer will be subject to a fine of $20,000 or 2 years imprisonment, or both. So again, a high penalty to prevent, or it is to act as a deterrent so that employers do not subject employees to victimization in the workplace simply because they made a complaint of discrimination, or they proposed to make a complaint of discrimination, or they participated in helping the victim who made the complaint. I'll briefly explain what kind of complaint you could make under the Discrimination Act. I call it Discrimination Act, but it's really entitled Employment Prevention of Discrimination Act. And for short, I say the Discrimination Act, because if we are saying, if you make a complaint under the Act and you're victimized for making the complaint, I should at least give a slight idea as to what you are protected by under this Act. Now, essentially, the Act seeks to protect an employee from suffering any kind of direct or indirect discrimination on the ground of sex, sexual orientation, origin, political affiliation, political opinion, trade union affiliation, pregnancy, maternity, family responsibility, medical condition, disability, to name a few. I think there might be 2 or 3 more that I left out. So that if as a result of one of these characteristics, if as a result of your age, you suffer some detriment in employment, then you could found a complaint under the Act. So the aim of the Act essentially is to protect an employee from direct or indirect discrimination during the hiring process, in respect to the terms and conditions that are given to the employee, in respect of the provision of facilities or services given to the employee, in respect of workplace opportunities such like promotions, transfer, training, advancement, to protect you from discrimination in how discipline and dismissal are applied, and any other employment benefits. So that if you as an employee, you read this Act and you feel that you are suffering that kind of direct or indirect discrimination, but on the ground of one of the protected characteristics, and like I said, the protected characteristics are like age, origin, political affiliation, etc. So as a result of these characteristics, you are not getting the same access to promotion as other employees. As a result of your religion, you're not getting the same access to transfers and training as other employees, then you can make a complaint under the Act. And if after making the complaint, or because you've threatened to make the proposed to make the complaint, you are threatened and say, well, if you made that complaint, I'm going to make your life a living hell. Or if you suffer actual victimization after you've made that complaint, or after you've helped someone who made the complaint, then you are protected by section 37, which prohibits the employer from victimizing you on the ground of making a complaint, on the ground of proposing to make the complaint, or on the ground that you help somebody who made the complaint. And like I said before, the once you make the complaint under section 37 and say, look, I was victimized because I made a complaint for discrimination, the chief labor officer can inquire into the matter. I mean, if it is found that there's enough evidence that you were victimized, then the employer can be liable to pay a fine of up to $20,000. So you're protected from victimization if you make a complaint for sexual harassment, and you're protected from victimization if you make a complaint under the Discrimination Act. Now, the third and final way that you see some form of protection, and I say form of protection because it's not preventative, it's actually after the fact. Then you would be able to found an action for unfair dismissal under section 30 subsection 1 Roman numeral 4. Now, this section actually says an employee who is dismissed because he made a complaint about the employer involving an allegation of a violation of law, an allegation of a violation of the contract of employment, or an allegation of a practice that violates the law or a contract of employment, then that employee will be considered as automatically unfairly dismissed. And what's important about this is that the employee will be entitled to 2 types of compensation. The employee will get the basic award, which is compensation for unfair dismissal, calculated as a weekly portion of your wages multiplied by the number of years you've worked. But secondly, the employee can get up to 52 weeks wages in addition to that. And it's a penal clause really, which is penalizing the employer for dismissing you for such a shallow reason. In other words, an employee should be able to make a complaint about a bad employment practice or breaches of its own employment contract without fear of being dismissed. And I think that's why the Act allows 2 types of compensation to these kinds of employees. So it's not quite protecting you, but hopefully the employers who know the section will be deterred from dismissing you because of the financial liability they can incur if it does in fact happen. So law only protects victimization in 3 instances: sexual harassment, when you make a complaint for sexual harassment; 2, under discrimination, when you make a complaint for discrimination; or 3, when you were dismissed after having made a complaint. In all of the instances, there's really no direct protection for victimization. So what do if you feel you've been victimized? If you're not sure if what you're experiencing is victimization, the first thing I would suggest is that you consult with a labor attorney, consult with the labor office, or consult with your union if you are a member of a union, and speak about the incident and get some advice on whether it constitutes victimization by the legal standard and what, if anything, you should do. The second thing is something I said earlier, which is record keeping. Victimization is something that requires proof because people can explain it away or just deny it. Say, oh no, they're just sensitive. I only said that as a joke. There's no real relationship difficulty. Oh, that performance review was bad because they really didn't perform well. If it can be explained away by some other reason, it is harder for you to succeed with a victimization claim. So you're going to have to do good record keeping, have audio recordings, keep emails, letters, have a witness if possible to show that this action only started, the victimization only started after you made that complaint, or it intensified significantly or noticeably after you made the complaint. But like I said, if in doubt, contact a labor attorney, contact the labor office or your union representative. So I hope you learned something today about what is victimization, the few instances that the law in Barbados protects you against victimization, and what to do if you feel you've been victimized. So thank you for joining me for another episode of Labor Matters, and I hope as you gain knowledge of your labor rights and procedures that you will adhere to good labor practices. See you next time.